Yes, please go ahead.
Welcome you all from Burmese Rohingya Organization UK. It's a great honor to see all of you, and I would like to express many thanks to all our speakers and our moderator Akila, Mr. Thomas Cantena, Mr. Arsalan Suleman, and Miss Erin. Thank you so much joining our event today. It's a great pleasure to see all of you. And also, I would like to speak a little bit, just a few seconds on with Rohingya language. Assalamu alaikum wa rahmatullahi wa barakatuh. Ara Rohingya by Ain Buina Zantara Deshar Butura, Aso Deshar Bara, so Begunar, Assalamu alaikum. To Ajara Gua event good de Iboye, especially Rohingya case of called Tinan Soler Akan ICC, Arakan ICJ, Arakan Diki Argentina. Especially Tiniano Babatara Hota Huyum, Erebutore Ajadiki. 23 November মাঝে বর্মা তু সমাজ বাদে আকান রেপোর্ট তুলা ফুরব বর্মায়ে প্রভিশনাল মেশাস হদে ইনরে হদ্দুর গজ্জে ন গরে হদ্দুর দিকি জেনোসাইড অহন সলর হদে ইয়ানর আরা হাইলাইট গুরি হতা হইম তো অহন আরা ইংলিশ প্রোগ্রাম শুরু হইব ওই বাদে লাস্ট মাঝে অনরা বাই আইন বইনান বেগুনরে আজারা যত রোহিঙ্গা আরার হতালই আরার বাবতে কি সলে দেয়ার হামাকা আরার কুমতু জানানসা জানা ফুরব আতাল্লা বলি আরার ইভেন্ট ফুরা এবার লাস্ট কোয়েশ্চেন এন্ড অ্যান্সার বাদে এর দিকে বেশা বেশি শতর মানুষ এর দিকে রেজিস্টার হইয়ে তো দিকে আরা দিকে আই দিকে অনারের রোহিঙ্গা হতালই আর মতা বুঝাইবার লাইসুম তো ইয়া দিকে আরার ইংলিশ প্রোগ্রাম লই হতা শুরু হইব So I would like to hand over to our moderator now, Akila. Please continue. Thank you, Akila.
Great. Thank you, Tinkin, and thank you to everyone for joining us today. As Tinkin mentioned, I'm Akila Radhakrishnan, the president of the Global Justice Center, an international human rights organization dedicated to advancing gender equality through the rule of law. We combine legal analysis with strategic advocacy to ensure equal protection of the law for women and girls. I'm going to start with a little bit of housekeeping. In terms of our run of show, we'll first have a moderated Q&A with our amazing panelists. After that, we're going to open it up to a Q&A. If you have a question, please ask it in the Q&A, not the chat box, which you'll find at the bottom of your screen. You can ask the questions at any time. We'll be monitoring them throughout the event. And if you are targeting your questions to any particular panelist, please feel free to note that. And finally, as Tinkin mentioned right before we close, he'll briefly summarize today's conversations in Rohingya at the end, since we have quite a few attendees today from the Rohingya community, including those in Cox's Bazar. So to get us started, I'm going to briefly frame this discussion. So starting in October 2016 and again in August 2017, Myanmar security forces engaged in so-called clearance operations against the Rohingya, a distinct ethnic Muslim minority in Rakhine State. The operations, in particular those started in August 2017, were characterized by brutal violence and serious human rights violations on a massive scale, including rape and other forms of sexual violence, indiscriminate killings, arbitrary detention, torture, beatings, and forced displacement. These acts followed decades of systematic discrimination and persecution of the Rohingya, including the passage of laws that stripped them of their citizenship, restricted their religious freedoms, as well as their reproductive and marital rights. In September 2019, the UN fact-finding mission concluded that the state of Myanmar has breached its obligation not to commit genocide and found that Myanmar continues to harbor genocidal intent towards the Rohingya. Then, in November 2019, 3 different avenues for justice and accountability for the Rohingya opened up, which is the focus of our conversation here today. The Gambia filed a case at the International Court of Justice. The ICC's pretrial chamber authorized the opening of an investigation into the situation in Bangladesh and Myanmar. And our host today, Brooke, filed a universal jurisdiction case in Argentina against senior Burmese officials, including Aung San Suu Kyi. We're fortunate to have counsel in 2 of these cases joining us today. Since then, the ICJ has issued provisional measures in the Gambia versus Myanmar case, and 3 other states have announced an intention to intervene in the ICJ in support of the Gambia, Canada and the Netherlands, and the Maldives. There have been important procedural developments in the Argentinian universal jurisdiction case, as well as in the ICC's investigation. And the UN created the independent investigative mechanism for Myanmar, which has continued its important work to build potential cases. But this has also come against a backdrop of increased conflict in Rakhine State, the COVID-19 pandemic, a seemingly intractable solution in Bangladesh with over 1 million Rohingya refugees in camps in Cox's Bazar, and recent nationwide elections in Myanmar that were neither free nor fair. The country's electoral commission canceled elections in 9 of 17 townships in Rakhine State and excluded Rohingya candidates from running for office. So a year on, where does this leave us? Have these accountability measures been effective? Have they brought forth any concrete changes for the Rohingya in the short term? These are some of the questions that we're seeking to answer today, which actually marks the day that Myanmar's second report to the ICJ on compliance with provisional measures is due. And on this note, let me stop talking and introduce our fabulous panelists. First, we have Tun Khin, who's an ethnic Rohingya Muslim from Arkan State in Myanmar and the president of the Burmese Rohingya Organization UK, our host here today. Tun Khin is a prominent activist for the Rohingya people, and his tireless advocacy for the Rohingya cause has taken him around the globe, and he's been extensively recognized and honored for his work on the cause of the Rohingya. Next, we have Erin Rosenberg, who is the senior advisor for the Ferencz International Justice Initiative at the United States Holocaust Memorial Museum's Simon-Skjodt Center for the Prevention of Genocide. Wow, that's quite a lot. Previously, she served as a legal officer for the Trust Fund for Victims at the International Criminal Court. Arsalan Suleman is counsel in Foley Hoag's international litigation and arbitration practice, who serves on the legal team representing the Gambia in the Rohingya genocide case, and argued part of the case before the ICJ in December 2019. He's also the former acting US Special Envoy to the Organization of Islamic Cooperation. And finally, we have Thomas Ojea Quintana, who's an Argentinian lawyer and lead counsel in the current universal jurisdiction case pending in Argentina. He's currently the UN Special Rapporteur for Human Rights in North Korea and was formerly the UN Special Rapporteur for Human Rights in Myanmar. Okay, let's start getting into this and starting with a little bit of an insight into the ongoing accountability processes. So Arsalan, I'm going to start with you. Since the Gambia filed a case against Myanmar last November at the ICJ, there's been quite a lot of fanfare, and rightfully so. As counsel, can you give us some insights into what the advantages of a case at the ICJ and under the Genocide Convention might be, and what are some of the potential legal outcomes of the case?
Thanks, Akila, and my thanks to Tun Khin and the Burmese Rohingya Organization of the UK for hosting this panel discussion, and to everyone who's joining us here. Well, the main advantages really are, well, there are several. First of all, it's the best way of holding the Myanmar state responsible. Myanmar as a state is a party to the Genocide Convention of 1948. And as part of that convention, it has undertaken upon itself the obligations of that convention, which are to prevent genocide, to punish genocide, and to not commit genocide. And so in order to hold the state, the government itself responsible, this avenue is the best way to do so, because it provides the jurisdictional procedures for that. Under Article 9 of the Genocide Convention, Myanmar has given its consent to take any disputes that relate to the interpretation, application, or fulfillment of the convention to the International Court of Justice. So, if you just break that out a little bit, number one, the advantage is that you have a forum, you have a mechanism to hold the state itself responsible. Number two, as others on this panel can point out, and you yourself, it's so difficult often in terms of seeking international justice and accountability to actually find a forum where you might have jurisdiction to hold the perpetrators accountable. And in this case, under the Genocide Convention, we do have a very clear jurisdictional basis, because Myanmar as a state consented to the jurisdiction of the ICJ. And so you have that sort of requirement fulfilled with their consent to that jurisdiction as part of their ratification of the convention. Another advantage is that the ICJ, the International Court of Justice, is the highest court of the United Nations. It is the principal judicial organ of the UN. It's often called the World Court. So in terms of states, in the international system of nation states, the ICJ is the top court, and that in and of itself symbolically is important, because it's an opportunity to hold Myanmar accountable for this most horrendous of crimes at the world's most elevated judicial body in the UN system itself. And finally, one other advantage that I think we'll probably be discussing a little bit later is the fact that under the provisions of the International Court of Justice, under its statute, there is the opportunity to seek and request and to obtain what are called provisional measures. These are measures that the court can impose on an urgent basis in order to preserve the rights of the parties during the pendency of the dispute. And that is what the Gambia sought as part of its application. In this case, it sought the court on an emergency basis, on an urgent basis, to hear the Gambia's request for provisional measures in order for the court to order Myanmar not to commit further genocide and to take action to prevent genocide, preserve the evidence of genocide, and to report on implementation. And the reason for that is just the urgency of the situation, as was made clear in the report of the United Nations fact-finding mission in 2019. All of the indicia of genocidal intent and genocide that it had outlined in its 2018 report were not only still present, but were actually further enhanced. And so the risk of ongoing genocide against the remaining Rohingya population in Myanmar was not only remained present, but was actually even more concerning. And so for all those reasons, that forum and the ICJ, was a very advantageous forum. And of course, just at a baseline, the situation for the Rohingya is urgent, it's dire. And so it was important for the Gambia to exercise its access to that court on an urgent basis, and which is why it did so.
Great, thanks so much, Arsalan. And I think it's really, this is why it was one of the most groundbreaking things that's happened. Is those of us who worked on Myanmar for a long time know that domestic accountability is not possible, and due to ratification, forums are limited. But and I think we're going to get into this now. Is there are some innovative and creative ways that different, individuals and courts are trying to get around some of these jurisdictional limitations. So Erin, I'm going to turn it over to you a little bit to talk about what's going on with the ICC. So in November 2019, the ICC's pretrial chamber authorized the opening of an investigation into the Myanmar-Bangladesh situation. Can you give us a brief background on the ICC investigation, any advantages and disadvantages to the ICC, and an update on the current status of the investigation, including the recent request by victims to have justice brought from The Hague to somewhere closer to the Rohingya community?
Thank you, Akila. And before I begin, I just wanted to also thank Khin as well as my fellow distinguished panelists. It is truly a pleasure and an honor to be here with you today to discuss this important topic. As Akila mentioned, I am with the United States Holocaust Memorial Museum Center for the Prevention of Genocide. The Simon-Skjodt Center for the Prevention of Genocide seeks to encourage worldwide action to prevent, halt, and promote justice and accountability for modern day acts of genocide and related crimes against humanity. Now, in terms of promotion of justice and accountability, one of the important international mechanisms that exists, as you just mentioned, Akila, is the International Criminal Court. So in terms of what is happening at the International Criminal Court, to begin, I would just say one advantage of the International Criminal Court is that the prosecutor has the ability to open of her own initiative an investigation into potential crimes that fall within the jurisdiction of the court. That is genocide, crimes against humanity, and war crimes. So because of that, the prosecutor began an investigation and has now sought the approval of the pretrial chamber, as you mentioned, which she received. However, and this will make more sense in terms of a disadvantage, one of the misunderstandings about the International Criminal Court is the notion that it is a world court or a universal court. In fact, it is necessary to have jurisdiction, not only over the crimes, but also what we refer to as territorial jurisdiction. That means that an element of a crime must either have been committed on the territory of a state party or by a national of the state party. So what that means is that at the International Criminal Court, what has been approved is an investigation only into those crimes for which an element of the crime occurred or may have occurred, is alleged to have occurred on Bangladeshi territory. That is because Bangladesh is a state party, whereas Myanmar is not. Right now, the focus of the investigation is on two crimes. The first being the crime of deportation, and the second being the crime of persecution. Persecution is essentially, to just explain for the non-lawyers, you can think of it like bullying. Bullying may be that someone is hit, someone is verbally abused, their property is destroyed. When it's being done to harass the person, that's bullying. Persecution is the same. There is an underlying criminal act, which may be killing, which may be destruction of property, but it is being done to persecute or harass the group as a whole. So the persecution of the Rohingya population linked to the underlying act of deportation is what the prosecutor is currently investigating. Now, one of the other sort of interesting points that I would just highlight is that the investigation is actually looking at potential crimes from the 1st of June 2010 going forward. So it is not limited to the events of 2016 and 2017. And finally, in terms of your question about the victim's request, I would just simply say that at this point, there is the possibility to hold future hearings, as indicated by the pretrial chamber, potentially in Bangladesh. However, they chose not to take a further decision on this because of COVID. And so basically what they have said is that until it is clear that health-wise there is the potential to be on Bangladeshi territory, they're not going to move forward. The final thing that I would just say, however, in terms of a disadvantage about the ICC that I think is very important to underscore is that the International Criminal Court states operate under a cooperation framework. What that means is that states cannot be required to participate or to allow investigative actions. They are essentially asked to cooperate with the court. Myanmar has refused to do so. It has refused to allow access to the prosecutor into Rakhine State. And so this is a very serious impediment to the investigation, but the prosecutor continues in Bangladesh and with trusted sources within Myanmar to seek information about the crime of deportation, persecution, or other crimes that have an element that occurred in Bangladesh. Thank you.
Great, thank you so much, Erin. And finally, Tomas, I'm turning it over to you. So you're currently representing Burke and Khin in a universal jurisdiction case against Aung San Suu Kyi and other Burmese officials in Argentina. After initially being dismissed, the case has been revived on appeal. Can you please give us a little insight into the case, its current status, and what concrete measures can be expected from the outcome?
All right, thank you, Akila, and let me thank Mountain King for organizing this important event, and also salute to Arsalan and Erin. It's an honor to be with you here discussing these very important proceedings that we have all over the world. This is the case in Argentina, which is called universal jurisdiction case. So we are trying to use the universal jurisdiction principle, which allows to file a complaint in any court in the world when we are talking about serious and extreme crimes, international crimes, such as genocide. This is a principle that is still in process, but in Argentina has been accepted by some courts, and therefore with Tung Kim we decided to file this complaint first to ratify the extremely serious crimes that we are talking about. So using universal jurisdiction is to send a message that we are not going to tolerate, and Rohingya will not tolerate any longer these serious crimes. The case was filed in Argentina, which is in the other part of the planet, from Southeast Asia. And this was also a symbolic message to the international community that we are talking about genocide. And we, the international community, we shouldn't tolerate genocide. And it is a court in the other part of the world that will deal with this serious crime. Third, let me also tell you that the fact that the case was filed in Argentina also tells a lot about the, let's say, the colonial era implications. We are not talking about a court in Europe or in the US, but we are talking a court in a South American country, which is also a developing country, like some other Southeast Asian countries. And we think that that was also an important message to send to the international community and to the government of Myanmar. And another important issue is that it was the Rohingyas themselves, in this case, Mountain King, and now we are bringing some other survivors to the case. And it is the victims themselves that they are pursuing justice, seeking justice. And this is an important, I think, feature of this complaint of under universal jurisdiction in Argentina, is the Rohingyas themselves that they are trying to find the ways to seek justice, and they are committing and compromising their lives and their efforts towards this important objective, which is to seek justice and accountability for the crimes committed. At the same time, Akila, we should say that it is a case that also has an element of utopia, because we are talking about a jurisdiction which is in the, as we said, in another part of the planet. We use in Argentina Spanish language, so we will have a lot of issues with regards to interpretation. The universal jurisdiction principle itself is controversial sometimes, because some countries understand that it's an interference in domestic affairs, and we will have to fight back that kind of arguments. But we decided to file the complaint because we want to reinforce the accountability agenda. We thought at the same time that filed the complaint in 2019, and not too much time after the reports from the United Nations came out, also is a way to seek contemporary justice. The justice that the Rohingyas want to attain is contemporary to the crimes committed. The Rohingyas don't want to spend 20 years to seek justice for these crimes. And that's why we decided to file the complaint right away. And also to start collecting evidence and exchanging and engaging with the AAMM of the United Nations and all those organizations, civil society organizations that have been collecting evidence. And we are ready to engage with these civil society organizations to use their evidence and to bring them into the complaint, because there are procedural ways to involve them in the complaint. One more point, two more points, if I may. We have colleagues here who, Arsalan, who worked very hard and with a lot of success in the ICJ case, and also our colleagues at the ICC, International Criminal Court. It was not planned, we should say that. It was not planned that the three cases were filed approximately at the same time. That this shows that there is a coordination in the mindset about what is needed for justice with regards to the genocide in Myanmar. That was very interesting. We do not believe that there is any overlapping or contradiction among these three cases. On the contrary, they reinforce each other, they complement, and we are ready to move forward. We have, of course, some questions that we will have to face in the process, which, for example, you mentioned, Akila, the domestic procedures in Myanmar. We give for granted that those domestic procedures are not in compliance with international standards, let's say. But that for sure will be a discussion that, at least in our case, maybe a party, if they participate, will bring to the Argentinian court and say, what are you doing? We have our own commission of inquiry in Myanmar. We recognize that war crimes were committed. So that will be a very interesting legal discussion that we will have to have in the future. We don't have in the Argentinian case so far the counterpart. We don't have accused people at the beginning. And to conclude, the case is alive in Argentina. Just recently, the prosecutors of the ICC sent a note to the Argentinian court saying that the two cases reinforce that they do not see overlapping, that they do not see problems with due process principles like non bis in idem. So now we are expecting the Argentinian court to make the decision to open the investigation, and we have a lot of expectations about a positive decision, and that will let us have the opportunity to really bring a lot of proposals to further investigate the genocide and other crimes committed against the Rohingya.
Thank you so much, Shamas. I mean, I think it really does go to show that the abject failure of Myanmar to do anything about it, that you have, you know, a case proceeding in Argentina, the Gambia stepping up to take a case forward at the ICJ, really to show what an international effort this is to recognize the plight of the Rohingya. And, you know, Tomas, you also really importantly mentioned the engagement of victims. And so on here, I want to turn it over to Tun Khin a little bit to talk about the Rohingya community's response to all of these international measures, because despite them moving forward, they're far away. And so, you know, you know, they're both far away in geography and they're both far away in time. So Tun Khin, can you share a little bit about the community perspectives of these cases and what you hope the concrete outcomes are? You're still muted, Tun Khin. There you go.
Thank you. Most Rohingya don't fully understand the details of these international cases. You know, it is clear that grassroots participation in them will be limited. However, you know, justice at grassroots level is still very achievable. Like achieving justice for mass atrocities will require that we listen to the Rohingya communities, you know, who have been directly affected by the violence and displacement, you know, to ensure that their empowerment as survivors remain at the center of all our work, you know. Rohingya will likely be in the camps for many years. So justice at this point includes empowering the Rohingya community through comprehensive, transitional and transformative justice programs, such as through livelihoods, you know, education, and health program, which build a grassroots people-centered movement to define and achieve justice at the most local level. You know, international community, particularly human rights donors and government, should not shy away from cultivating, you know, cross-border exile Rohingya civil society movement. Especially, it should increase, dedicate funding, especially Rohingya-led civil society human rights group, both those are, both those that are established in the process of being established, and not only within Burma, but particularly among Rohingya refugee communities in Bangladesh, Malaysia, and diaspora further field. You know, it is clear that international community previous support for the Burmese and ethnic rights movement at the Thai-Burma border has given a whole generation of human rights activists the foundation to return work for their country's ongoing development. You know, Rohingya now find themselves the similar situation that like Karen, Shan, Kashin brothers and sisters found themselves 20 plus years ago. You know, they are now a handful of human rights donors and the government that actively support, cultivate Rohingya-led civil society organization. There are, however, you know, the emerging grassroots Rohingya activists and organizations, many that are women, youth-led, work in human rights advocacies, transformative justice, education, health, and other key issues that could benefit direct support, financial support, and broader networks. A continuing lack of direct support to Rohingya-led groups will only further disempower and prolong the disenfranchisement of the Rohingya. As such, it is critical, I want to point out here, in building credibility and gaining an equal seat at the table among power holders and even civil society allies when that opportunity for the engagement finally occurs. You know, international community needs to build an education pipeline for the primary level to university level for Rohingya refugees, you know, so that Rohingya youth have hope for the future. You know, refugee primary and secondary school, you know, intensive like O-level equivalent youth, adult, civil education program for Burmese and ethnic rights activists were a key factor in cultivating the whole generation educated activists, you know, in Burma today. The enormity of the situation that Rohingya now face requires such a leadership and education pipeline to reestablish and reconfigure that Rohingya ultimately have a fair chance to reconcile and rebuild their community in the also Burmese society as full citizen. I want to expand here like opportunities, you know, especially for Rohingya youth, you know, both refugees and in other countries in exile, participate university scholarship programs around the world. There are no university programs or scholarship that have directly engaged or focused on the Rohingya people. Given the ongoing genocide that the community faces, this will remain a considerable barrier for the community to have qualified representatives both in Burma and internationally. The international community, I want to point out here, they should consider expanding its educational and professional development programming to specifically benefit the next generation of Rohingya refugees and civil society activists wherever they may be, including Bangladesh or Malaysia or even the West. The nature of Rohingya genocide and widespread dispersal of Rohingya refugees and diaspora community necessitates, you know, a global approach to educational empowerment and leadership and development for the next generation. So overall, achieving justice for mass atrocities will require that we listen to Rohingya communities who have been directly affected by the violence and displacement to ensure that their empowerment as survivors remains at the center of all our work. That's all I want to point out here. Thank you.
Thank you so much, Khin, for presenting what that larger, more holistic view of justice is, one that really looks at what the needs of the community are, because, you know, all of these proceedings that are happening in different places, you know, that's one component and an important component, but really justice also has to translate down back to the community level and help the Rohingya move forward from all that's happened. So I think that what you've just provided us with is really important reminder. And I think that, you know, the other thing you continually noted is the ongoing nature of what's going on against the Rohingya, the genocide, the risk that exists. And so, Arsalan, earlier on when you were speaking, you talked about how one of the really important procedural benefits of the ICJ case is actually the ability to get a provisional measures order, something that can potentially be used as a tool in the midst of ongoing atrocities. And so I want to talk a little bit about that here, because today is the date that Myanmar is supposed to submit its second compliance report. So can you tell us a little bit more about background on the provisional measures order and the relevance of compliance with that order as the case is ongoing, as well as how it can feed into the ultimate outcome?
Yes, hi, thanks Akila, and really great comments from all the esteemed panelists. It's really been a pleasure to hear everyone's input and all the great points. Absolutely, you know, we've already seen the court through the provisional measures order make some important determinations that I think not only help to provide some measure of hope for the Rohingya survivors of the genocide, but also help to, as you said, it can serve as a tool. It can serve as a means of maintaining pressure and scrutiny on Myanmar to ensure that steps are being taken to remedy the situation, and a way of having some ongoing, for the court itself, ongoing monitoring to make sure that the risk of genocide, which is present, doesn't translate into a resumption of direct acts of killings and other direct acts of genocide during the pendency of the ICJ case, which, as we all know, can take some time sometimes. So on the 23rd of January of this year, we were all pleased to see the court's very strong and unanimous 17-0 decision in favor of the Gambia. And as part of that decision, it made the important step of recognizing the Rohingya as a group that, at least at a prima facie level, recognizing the Rohingya as a group which receives and deserves to receive the protection of the Genocide Convention. And further to that, it also ordered Myanmar to take a number of steps, including to take all steps available to prevent genocide, as well as ensuring that genocide does not occur, meaning that its entities under the state's control do not commit genocide. It was also ordered to preserve the evidence of genocide and to report back to the court. Provisional measures of the ICJ create binding legal obligations. So we know that the obligations under the convention itself are binding on Myanmar. In addition to those obligations under the convention, these additional obligations from the provisional measures order are also now binding on Myanmar, and parts of the provisional measures order follow the obligations of the convention, but they also go beyond it in terms of the evidentiary obligation, the reporting obligation, and the scope of the obligation to take actions to prevent genocide. We've seen a number of organizations, including Brook, but also the U.S. Holocaust Memorial Museum, publish some really important analyses of the provisional measures order and provide some interpretive analysis, which I think are very useful and helpful. And that's sort of part of the tool that this creates, is it allows this discussion, this debate to happen, which again, helps to keep that pressure and that focus and that scrutiny to make sure that the acts of genocide don't continue or don't recur in Myanmar. And I can mention that today is the due date for their second implementation report, and I can confirm that they did actually file that implementation report with the court. So that was timely filed by Myanmar. But also just beyond the provisional measures order, I do want to mention that what the Gambia is seeking through this action is very much in line with what Khin and others were talking about in terms of the focus on victims. This case was brought in order to provide justice and accountability for the Rohingya survivors and victims of these crimes of genocide. And an important element of the filing and of the memorial and other elements of the case, including the provisional measures hearing that happened in December of last year, when we had members of the Rohingya community there, including as part of the delegation of the Gambia to the court, to help to ensure that the court's attention was focused on the victims and survivors, and that they very clearly understood that there is a huge refugee population in addition to the huge 600,000 plus population of Rohingya still in the country, who are very much watching the case and have their hopes pinned on the case. So before I close, I just wanted to mention that at the merits phase of the case, so the Gambia filed its memorial last month. Myanmar will file by July of next year its counter memorial. The court may order additional rounds of pleadings, but once the full pleadings are closed, there will be a hearing on the merits, and the court will ultimately make a decision on the case and what the Gambia is requesting. And in terms of outcomes that the Gambia is seeking as part of its case, beyond the provisional measures order that was successfully achieved, Gambia is seeking a declaration from the court that Myanmar did violate its obligation, that genocide did indeed occur against the Rohingya, and that's an important function of courts, to declare truth and to make those declarations very clear and public. Gambia is also requesting that Myanmar ceases its wrongful violations and comes into compliance with the convention. But the Gambia is also seeking reparations. It's also seeking restitution. It's seeking an order from the court that would ensure that the Rohingya are able to safely and voluntarily return to Myanmar, that when they return, they are also free of the discriminatory policies that have been persecuting the community for so long, that they are able to return to their lands, and that if their property has been destroyed, that they get compensation for that. Again, as you mentioned, sometimes these cases take time, and this type of process might take time, but ultimately that's the goal. The goal is to achieve a measure of justice for the Rohingya, and at the furthest end, ultimately we would want to see the court make rulings that would ensure that the Rohingya not only are able to return, but they're able to return and they are able to get compensation and restitution for the damages that were done to them.
Thank you so much, Arsalan. I mean, I think it is, as an advocate and as someone who's worked on issues related to Myanmar for over 10 years now, there's actually a palpable difference. The ordering of provisional measures was an important tool for advocacy, to be able to re-engage with the international community, to say, you've spent too much time resting, and there's still a very serious threat. And so I think that it's really important to highlight what the ongoing nature is, and also to think about the fact that it doesn't have to rest on the resolution. So there are ways and steps that Myanmar could be taking right now as we speak to ameliorate the situation. It doesn't necessarily have an impact on the ultimate case of whether or not they committed genocide and some of the other things you talked about. And so on what some of these measures could be and how to look at the case, I want to turn it over back to Erin and then to Khin to talk about it. So Erin, first, the U.S. Holocaust Memorial Museum has started a new publication series entitled Practical Prevention: How the Genocide Convention's obligation to prevent applies to Myanmar. And as we all know, while the Bosnia case at the ICJ gave some indication on how to interpret the obligation, it was quite broad and vague. So can you tell us a little bit about how you have gone about giving substance to the understanding of this obligation, and what conclusions that's led you to, specifically as it relates to Myanmar's compliance with the Provisional Measures Order?
Sure, thank you, Akila. Well, as you just referenced, in the Bosnia v. Serbia case, the court held that a state's obligation to prevent and the corresponding duty to act arises at the instant that the state learns or should have learned of a serious risk of genocide. So we understand from this, I think pretty clearly, that a state needs to have an institution that is able to identify and assess whether or not genocide risk factors are present. And if they are, the corresponding duty means that they need to take steps at that moment to mitigate them. That seems pretty clear. We understand the obligation. What isn't clear from the court's jurisprudence, as you alluded to, is what is a genocide risk factor? What does that mean? What falls within it and what does not? As I think all of the panelists are aware, but for some of our attendees, just to explain briefly that the crime of genocide is often most associated with the act of killing, which is one act of genocide, but is not, there are other underlying acts of genocide, including imposing conditions of life, including severe mental and physical harm. So when we think about what a genocide risk factor is, we have to remember that we are trying to identify risk factors that may relate to any of the underlying acts of genocide, not just mass killing. So what the museum has done is essentially beginning by looking to see what frameworks are there. And very luckily, we didn't have to make up our own framework. In fact, the United Nations Office for the Prevention of Genocide has a framework for identifying atrocity crime risk factors. So that is genocide, crimes against humanity, and war crimes. They have identified 8 what they call common risk factors. So 8 risk factors for all of these crimes, and then 2 risk factors that are specific to genocide. The second risk factor is a widespread and systematic violations of international human rights law. So what we have done is taken that and said, well, let's break this down. What are international human rights norms? How do they apply? And what is this second risk factor in more detail? There's an organization by the name of the Jacob Blaustein Institute, which has conducted essentially this exercise. They've identified 22 genocide risk factors that are derived from international human rights norms. And so what we are doing is taking the work of the UN Office of the Prevention of Genocide, the Jacob Blaustein Institute's compilation, and applying that to Myanmar. And looking at what are the facts on the ground, what is occurring in terms of these potential violations of human rights. In our second report, we looked at the right to citizenship and the right to participate in public affairs. The right to participate in public affairs, just to explain, is actually quite broad. We understand it, I think, most directly as being about being able to vote, but it also includes, for example, the right to stand as a candidate, the right to serve in office, also to serve as in civil service in a government position. What we concluded on these 2 human rights is that Myanmar continues to violate both and to deny the Rohingya both of these international human rights, and that therefore they are not in compliance with the ICJ's provisional measures order because the denial of these human rights are genocide risk factors. And so it is incumbent upon Myanmar to take steps to mitigate, which means to correct the denials of these rights. What does that mean? Well, in the view of the museum, it means that in order to comply with the provisional measures, Myanmar must make actual policy and legislative changes. So this is not something that needs to be in a report. It should be something that is visible to everyone because it is a change of the law. In our next reports, we're going to be looking at other human rights, such as freedom of movement, access to healthcare, access to education. And as the report series develops, we will be discussing how these genocide risk factors relate to the crime of genocide and why it is so important that now Myanmar takes steps and that the international community pressure Myanmar to take steps to stop these denials of fundamental human rights and hopefully be able to prevent the reoccurrence of genocide. Thank you.
Thank you so much, Erin. And Khin, this morning, Brooke put out its second report assessing compliance with the provisional measures order, where you found that Myanmar is absolutely not in compliance with the order. So can you tell us a little bit more about the findings of your report, as well as what can be done by the ICJ and the international community to ensure compliance?
Sure. As far as what we can see, Burma is not following anything, not at all. They are following the provisional measures. I want to point here, about 3 points. Provisional measures order was actually intended to protect the Rohingya. We have right to exist. If the government really want to protect us, it would have granted us a full citizenship, the right to vote and stand in the recent elections. Instead, Myanmar still denies our existence, excluded us almost entirely from the election without the basic right to citizenship as Rohingya in our name, our identity. We are still vulnerable to genocide. The military has continued to kill Rohingya. In some recent cases, Rohingya men and boys were used as human shields by the military. They were taken and forced to walk ahead of military columns through minefields. Several Rohingya lost their lives that way, but we have also documented, killings outside of armed conflict zone. When Rohingya have been shot dead on site by shot dead on the side by the Temedor or police. Myanmar continues to make life unbearable for Rohingya in Rakhine State. They are trapped in their villages or in detention camp. It is a kind of slow death without access to livelihood, not enough food or medical care. That has been going on for 12 years now. The people are struggling to survive in IDP camps. The genocide is ongoing as far as we concerned. A few things can strengthen up provisional measures, making the reporting requirement public. That way Myanmar claim of compliance can be properly scrutinized. Requiring that Myanmar grant full citizenship Rohingya as part of measures to protect us, requiring Myanmar to cooperate fully with the UN and international investigations, including ICC and the ICJ and Argentinian case. Pushing for full citizenship for the Rohingya in Myanmar is very important. Support of Gambia cases follow the lead of the Canada, Netherlands, and Maldives. Much more need to be done to open universal jurisdictions. Thank you. And I think that's a really important international community. We would like to see much more need to focus on opening, more UJ case, as our friend Thomas have mentioned already. Now ICC gave already clearly, they mentioned this case can move ahead. So we're still waiting for the opening of investigation. So if we can have much more universal jurisdiction case in other parts of the, like Asia, much more in Europe, of course, it's really important. And also US and others, that would be much more effective. And same time, we have seen only Netherlands, Canada, and Maldives are joining, to this ICJ case. We really need other countries need to be joined, and that will encourage, that will give more strength and to for this case. I really hope that other countries will join. What I can say is how many more years we have to suffer, how many more years this genocide will be ongoing in Burma. It's been like January 23rd, is about 9 months now. ICJ ordered these provisional measures. Until now, there is no improvement. So that's why today we are calling that international community in action inaction of international community is really getting worse, and so it's really need that international community much more stronger action. Thank you.
Thank you, Tenkin. It's such a powerful reminder that despite the fact that things are moving, there's still so much more to be done. And I think the report that you've produced, the report the Holocaust Memorial Museum has produced, really gives a blueprint and a roadmap for the international community to think about what are the issues they need to be engaging on and what should they be seeking progress on. So I think that, all of this work is hopefully pushing us towards the holistic resolution of the situation of the Rohingya. And we've talked a lot about the ICJ here, but obviously these are going in parallel. So Tomas, I'm going to ask you a question. It's fairly novel for ICJ and criminal proceedings to be ongoing at the same time. And in fact, the ultimate decisions in the ICJ Bosnia and Croatia cases relied heavily on the jurisprudence and conclusions of the ICTY. Can you comment on how you think the ongoing ICJ case can help ongoing criminal efforts, including the one in Argentina and vice versa? Did we lose him for a second? Tomas, I think we may have lost you. I know you were having some, there you are, perfect.
Sorry, here you are. Sorry. Yeah, it was some connection problem, but I think you were making a question about the connections between the two cases, but and there is also a question. I saw a question, Akila, if I might respond to, because it is important question by someone from the University of Florence, Antonio Bultrini. I read it there, and his question is very relevant because he asks if there is a trial in absentia in Argentina, and the concrete response it is that we do not have trial in absentia. What this means is that as long as the perpetrator has not take the stand or become part of the case, he or she cannot be convicted. Now, but before that, we have a huge stage of the process, which is the investigative stage of the process, where we, the parties of the complaint, can, again, I said this at the beginning, open up a lot of initiatives to collect evidence, to bring the victims to the court, to seek information about social media. And on this, I want to just to let you know that Argentina has a treaty with the US on exchanges of information and so on. So since the outset of the case, we have in mind to reach out the social media in the US, specifically Facebook, but others, to further know what was their role in the incitement in Myanmar, especially starting in 2012 and onward. So we know that the WLM has engaged with Facebook, but not enough information was reported. We will follow up on that, for example. So we have a lot of initiatives with regards to investigating the case. What could happen at some point is that if the court in Argentina identifies a concrete perpetrator, the Argentinian court can issue a request for detention or extradition. We do not have a extradition treaty with Myanmar, but the Argentinian court could issue a warrant arrest and then request Interpol to issue a red notice. So that could be very interesting developing in the case. But again, we are now waiting for the decision of the court to open up the case. I really like what Arsalan said about the first objective of the case at the ICJ, which is that the truth is declared by the International Court of Justice of the United Nations, that the truth is declared. Of course, we all of us who are working and with the Rohingyas, trying to seek justice and accountability for the state itself, as it is by the ICJ case, but for the individuals as well as the ICC and the Argentinian case, seeking individual criminal responsibility. We don't have at all any doubts about what happened in Rakhine State. I have been the Myanmar reporter for 6 years. I visited Rakhine 4 times. I've been in Butidong. I've been in Mondo. I visited many times Ao Minh Alar Quarter. And for me, it was very clear at that time, and I regret that I wasn't able to really introduced in my reports to the United Nations the reasoning about how these genocide risk factors that Erin was talking about were already present, at least starting in 2012, with the populations of Rohingya being holding these quarters, which I call ghettos, like Aum Mingalar. I visited Mainbourne and some other IDPs, many IDPs in Rakhine State. I am a witness of how all these genocide risk factors were present even starting in 2012. But for the people in Myanmar, especially, the whole citizenship in Myanmar, the whole communities, the ethnic minorities in Myanmar, the question about the truth of what happened in Rakhine State is being disputed constantly by the government and media in Myanmar, so that the ICJ at some point declares that genocide was committed in Rakhine State against the Rohingyas. It will be a milestone and very important. So we are looking for that as well. We want to reemphasize the truth about what happened. And we will engage with the ICC prosecutor's office. We already have contact because we will share information probably and evidence, and we will try to coordinate strategies as much as possible. And we are also very expectant about the case at the International Court of Justice. We really think that this was critical that the Gambia took the decision to bring this case to the court, and now that they have 3 other more states supporting the case, is very, very important. Of course, we regret that the Security Council of the United Nations avoids the decision to send the case to the International Criminal Court. We know the political dynamics, different political interests, but it is really regrettable, and it will be a lesson learned from the Security Council not to take responsibility of this serious case of genocide committed against the Rohingyas. Let me see if I have something else to say, because I don't know if I will have the floor any other time, Akila, but yeah, I will stop there.
Okay, great. Thank you so much for that answer, and for also picking up on the question about the trials in absentia, because I think that is one of the questions that we all have is, what are the possibilities to actually arrest someone and try them in court? And so that was really helpful to get a little more background on that. So we're going to move into audience Q&A now. So thank you so much to those who've already asked some questions. I'm going to line those up. Those of you who have questions, please feel free to use the Q&A box to ask any questions that you have. And so, I may take moderator's privilege to combine some of them, et cetera. But to start with, it looks like Arsalan, I'm going to start with you. There's kind of 2 questions. I'm going to combine them for your reflections. And so one is, some of your co-panelists here have called for more parties to join the ICJ case. And so we have a question here about, is that possible? Is it desirable? And are there any other states, I think, beyond those that have been referenced here today that are considering it? And kind of similarly, thinking about the ICJ, there's also a question about the potential to scale up European Union sanctions regimes as a part of, linking it to the ICJ's provisional measures order. So if you have any reflections on whether you think that's useful, and Tudkin, I think maybe if you want to come in on the second one too, but we'll start with Arsalan.
Thanks, Akila. So there are a number of states who are in touch with the Gambia to discuss various ways in which they can support the Gambia in the case. And we certainly would welcome any state that does wish to support the case in various ways to be in touch with the Gambia directly and to make that offer of support or desire to support clear. For some states, that support might come in the way of potential intervention in the way that Canada and the Netherlands and the Maldives have indicated. But that might not be the case for all states, and it might not, it's not necessary that every state that wants to support intervene. There are other ways in which they can make their support clear, including through public statements at the UN, or through press releases or other bodies. Certainly, the UN General Assembly's overwhelming passage of the resolution on Myanmar just a few days ago, 131 states voting in favor of it and over 100 sponsoring it, is a great sign of the international support and attention to the issue. So, again, I'm not sure of any specific states right now who are contemplating intervention other than those that have already been mentioned. But to the extent that there are, it can potentially be helpful depending on who is intervening, and certainly depending on whether they are actually coordinating with the Gambia, because that coordination is certainly essential. In terms of the question about the EU sanctions and sanctions from other states and linking them to the Provisional Measures Order, I think it's a great question, because it's sort of a reminder that these cases, and as Tomas said, they're all complementary, they're all important and complementary. But these cases are just one element of the broader international campaign to resolve this issue and to bring the Rohingya to a situation where they are no longer subject to genocide and persecution and all the discriminatory policies that they're facing, that they can actually have a life, they can actually live in their home country. And sanctions are an important tool for any state. And so for states that do have sanctions in place, there are a number of states, including the United States, the United Kingdom, and other EU member states who have sanctions in place against individuals in Myanmar, given their complicity in the acts of genocide and other gross human rights violations against the Rohingya, and linking those sanctions to particular policy outcomes, including outcomes that can fall within the ambit of the Provisional Measures Order, as described in particular by Erin and Khin when they're talking about what does it actually take to implement the order. Actual implementation of the order means seeing real policy results on the ground and a real change in the circumstances for the Rohingya. And so in that sense, linking sanctions and other policies to that order and the implementation of it and specific policy outcomes on the ground, I think is certainly a very reasonable and wise option for governments to consider as sort of tools to measure the effectiveness of the sanctions and benchmarks that the target of the sanctions, the Myanmar government, can use to ensure that, well, if we achieve these certain steps, if we take these certain measures, if we ensure that access to livelihoods are restored, that discriminatory policies are undone, that the NVC cards aren't being forced upon the Rohingya at every turn, then maybe there can be some sanctions relief. And I think that's certainly something to be considered.
Great, thank you so much, Arsalan. Khin, do you want to add anything on the issue of sanctions?
I really like that question, European Union and ICJ order. Unfortunately, I have to be, as a big teams, there is much more can do by the European Union, but European Union is not doing any sanctioning. Instead, is very disturbing that European Union ambassador in Burma and others, they are appreciating to the government. We've been excluded from this country. Still, these countries are, donor a kind of funding to election commission, which is a racist election. Racist election commission, they are supporting it. So I think it's much more broader, a stronger advocacy needed. And these countries we've been campaigning for many years, to be honest, we are alarming to the international community. When our advocacy since 2012 and, after state organized violence happened, there are elements of genocide. Since 2014, we are doing a conference in London School of Economics, genocide is going on in Burma against Rohingya. They ignore it totally. So now this is time, I think at least they should take action. They can see current situation is more dire and genocide is ongoing. If international community don't listen this time, I don't know what to say then. It's never again whenever this happen. So now this is going under the nose of international community. Thank you.
Yeah. Well heard, Khin. And speaking of kind of the international community, Erin, I'm going to ask you to answer this question, and others can come in on this if you want. But we have a question about the recent elections in the U.S. and what impact you imagine they may have on the cause of justice for the Rohingya, and noting that the U.S. has been relatively more active in its punitive measures against Myanmar. So do you want to comment on that, and then I'll ask if anyone else does?
Sure. Thanks for that question. And I see that there was a question from Thomas McManus in the chat, which maybe I'll combine these actually. So this was a question about the Holocaust Museum's determination in 2018 that what was occurring was genocide. And the question is, why did it take that long? And the very straightforward answer is because the museum wants to ensure that it acts with appropriate deliberation and is fully grappling with the facts that are available, the law, etc. So it is a process that takes some time. It's also a process, I would point out, that is not carried out by museums normally. It's actually a very important process of governments in the United States of America. That would be the State Department. The United States of America the government has not yet made a genocide determination for Myanmar. And so just to add to sort of this conversation about what we might see, this is not necessarily a Biden versus Trump, but rather to say that generally encouraging the US government to make a determination is quite important. And it is something that we do think that the State Department should do either now in the final months of the Trump administration or the incoming administration of President-elect Biden. This is something that has been stalled, and it quite frankly needs to be unblocked. And it's something that I think is a clear policy act that that should be done. I hope that answers the question.
Yeah, great. Thank you so much, Erin. I'm going to take a little bit of moderator's privilege here and ask a question that, as an organization that works a lot on Myanmar sits with us, which is, and Tomas, I'm going to direct this question to you as the former special rapporteur, which is that, we've talked a lot today about the fact that justice mechanisms in their formality serve a purpose. It's to hold a state accountable, it's to convict an individual, but really what needs to happen as well as a part of this is to identify the elements that allow a society to move forward. And I think an area where there's very little conversation these days is around the justice and accountability picture for other ethnic groups. Khin mentioned the solidarity of other ethnic groups, the Shan, the Kachin, the Karen, who've long suffered at the hands of the military. It may not be genocide, but there's certainly other international crimes that have occurred. So maybe, do you want to comment a little on what you think it might take or what is needed to help move this larger accountability conversation for Myanmar forward? Because I think that for peace and democracy to take root in the country, addressing the plight of the Rohingya is certainly one of the key aspects, but so too is bringing this justice picture for everybody that exists in the country.
It's difficult to respond to this kind of very, very difficult scenarios, Akila, but the questions need to be made. And during my tenure as reporter, I addressed also the crimes against humanity committed against the Karen, the Khin, the Shan state people, the Shan people. I visited Chin state as well, and definitely the pattern of abuses against the ethnic minorities in Myanmar was I would say, was similar among all ethnic minorities. Now there was a difference with the Rohingya people. The other ethnic minorities has been struggling and fighting the majority Burmese for decades, the longest civil domestic internal armed conflict in the world. We have it in Myanmar with basically with these other ethnic minorities. But in the case of Rohingya, even at 2012, I was the reporter on the ground in Rakhine State, and there was no ethnic minority armed group on the Rohingya side. ARSA, the Arakan Rohingya Salvation Army, didn't exist at 2012. So there is an important difference between the Rohingya ethnic minorities and the other ethnic minorities. But with respect of the treatment of the military against them, we are talking basically about the same kind of crimes. I'm not sure if we were able to reach the conclusion of genocide committed against other ethnic minorities. Now, during my tenure as a reporter, I can speak about that only now, because to speak about what should be done now is very difficult. But I do include in my reports the need to address serious human rights abuses many times. I discuss it with Madame Aung San Suu Kyi many times, the need to establish a truth commission, trials, whatever it is. The military shouldn't go away with the crimes committed against all ethnic minorities. So it is clear for me, and I'm sure for many of you, that the problem here is the role of the military in the process of the democracy, and the role of the military in dealing with the state issues, affairs, and therefore I support sanctions. I support the sanctions many times. Be very clear about that. I support the targeted sanctions, especially against the military. And just one last point, Akila, if I may. I remember in 2012 when there was a lot of discussions about how to qualify the violence in Rakhine, and the government of Myanmar was pushing to qualify it as communal violence. I'm sure you remember, clashes between the Rohingyas and the ethnic Rakhines in Rakhine State. And beyond discussing what happened with the Rakhine people, ethnic Rakhine in Rakhine then with the violence, I do remember that in 2012, I organized a session of dialogue in situ between ethnic Rohingyas and ethnic Rakhine people, and they were sitting together after the violence, and we tried to build a bridge for discussions. It was very difficult, but the fact is that they were sitting there, and that at that time showed to me that there was another element behind the violence, and that was the military. It was very clear. My point is that, and we see now that there is some reapproachment between the ethnic Rakhine people in Rakhine State and the Rohingyas. And I really believe that there is empathy between the ethnic minorities, including Rohingyas. And there is a need to build on that. That's what I believe. That could be some of the responses, and the internal armed conflict need to finish, actually, and that's critical. And the international community should push the current authorities in Myanmar to put an end to the conflict, because the armed internal conflict also gives a lot of justifications and arguments to the military to continue holding power and to commit human rights abuses.
Yes, thank you so much for that. I mean, I think you're right that there is in this moment now much more ethnic solidarity that we've seen. I was at the ICJ in December when the provisional measures arguments were happening, and so too was Khin. And you had representation of a range of ethnic groups that showed up in solidarity to support and say, we stand with the Rohingya. We understand what happened. You know, this is a common measure for us, and we want to see justice move forward for the Rohingya. And so I think that is a really important change. So we're just about running out of time. Arsalan, I've got 2 ICJ specific questions I'm going to ask you very briefly. So the first one is specifically on Facebook and whether or not Facebook is cooperating and providing information and documents to the Gambia as a part of the, there's kind of a separate process in the US about obtaining that evidence. And then second, we've got a question that asks about to what extent the ICJ case is largely symbolic, given that China is always likely to shield Myanmar at the UN Security Council. Will any enforcement of a potential ruling be possible?
Thanks, Akila. So, yeah, I wanted to comment on the effort by the Gambia to get documents from Facebook, because Tomas was mentioning the process that is being undertaken in Argentina along the same lines. But yes, the Gambia has filed a request under a provision of U.S. law in order to seek information, documents, evidence that are in the possession of Facebook that are relevant to the ICJ case. And thus far, Facebook has been resisting that request. It has sought to persuade the court. This request for the documents is being heard before the U.S. District Court in Washington, D.C., so the U.S. Federal Court here in Washington, D.C. Facebook has been seeking to resist that request, to not comply with the request, and they continue to do so. I think last week there was a hearing on the matter before the magistrate judge who has been assigned to the case. And there were arguments being made by both sides as to whether the Gambia's request, should be ordered by the court, and to what extent Gambia can receive the information requested, or whether it's protected by certain statutory protections. We'll see what the court ends up ruling, but thus far, Facebook has not directly given the Gambia any information. Facebook has, according to public reporting that we have seen from news reports who've been covering these requests and who've quoted the head of the IIMM, Nikumjian, they have received some information from Facebook based on requests that the IIMM had long made with Facebook. They've had requests pending with Facebook for over a year. Only recently did Facebook start providing some of that information, and according to Nikumjian, it's only been a very small amount of the information ultimately requested. So, I think there remains a lot more in terms of evidence and materials that are requested that have not been fully responded to. And I think everyone on all sides really hopes to see more compliance and more sharing of the information that's available. On the second question, is the ICJ case merely symbolic? No, absolutely not. It's not symbolic. In fact, I think it has really helped to open up so much of the opportunities for achieving justice and accountability, because it is such a high-profile forum. It is a forum where Myanmar, cannot avoid accountability. They have consented to the jurisdiction of the court, and it is the highest court that states can be brought to. And the judgments of the court are binding on the parties to these cases. So the rulings of the court, the provisional measures order, and the ultimate decision on the merits are and will be binding on Myanmar. And we have every confidence and reason to believe that Myanmar will comply with the court's orders and the court's judgments. I think historical and statistical analyses looking at ICJ judgments have found that by and large, states do comply with the judgments of the ICJ for a number of reasons, including the reputational cost to not being in compliance with orders of the court. Even though the questioner had mentioned that, the Security Council may be hamstrung from taking measures to enforce an ICJ decision. We don't have to look to that, eventuality or potential action. We can look to the fact that, most states do comply with orders of the court and would be under significant pressure to do so. But even if the Security Council were not able to act, and I'm not saying that they wouldn't be, because when the ICJ makes rulings, that can also change the dynamics of decision making on the part of various parties who may be members of the Security Council itself. But for the ICJ to make a ruling, make a determination, particularly one that finds that genocide occurred and that Myanmar is responsible, I think that would again be a really groundbreaking decision and would change fundamentally the dynamics for a number of states in terms of their political and policy-based considerations as they engage with Myanmar directly. I think you would see a lot more efforts and a lot more specific targeted measures that could leverage such a decision and allow states to align their policy to see such a decision implemented.
Okay, great. Thank you so much, Arsalan. So we've unfortunately hit the end of our time here, but we talked about a little bit in the beginning, the importance of engaging with the community. So I'm actually going to turn this over to Khin, who's going to briefly summarize this discussion and lead some conclusions in Rohingya for those of them who are watching from the camps today. Thank you.
Assalamu alaikum wa rahmatullahi wa barakatuh. Arar deshabutor asode solak পর্যন্ত আরার বাই আইন বই নাই যেন তারা বেশি রিক্স মাঝে আছো যেন তারা এখন জেনোসাইডের ফেস করার স্পেশালি চকট মরাও উ আইকিয়া পকট রেতে ডাং তুই বাদে মন্ডু বুসি ডাং ও ঠন কলম মাঝি অনরা বেগুনরা আরা মনত গরি অনরলা দোয়া গরি আর দেশের বারকুলে বাংলাদেশত আছো সৌদি আরব আছো মালয়েশিয়া আছো পাকিস্তান আছো অন্য দেশকলত আছো বেগুনরে আন্তর্গত আসসালামু আলাইকুম ওয়া রাহমাতুল্লাহি ওয়া বারাকাতুহু তো আজারা বসিদে ইবা মুজলিস হইদে আজা সমাজ বাদে বর্মাতো প্রভিশনাল মেশাস হইয়ারে যা ফে আমেং হইয়ার হদুন দিকি কোর্টত হদুন দিকি প্রভিশনাল মেশাস ইনরে মানিবাল্লা আইসিজি কোর্টত জানুয়ারি 23 তারিখ মাঝ হদুন অর্ডার নিয়ালাই তো ইনলা 4 মাস বাদে তারা তো রিপোর্ট করা হচ্ছে ইবাই আরা হন নজানি মত গ্রাউন্ড সিচুয়েশন হন কিছু ন বদলি আজ আমাতা আরোগ্য সমাজ বাদীয় বর্মাতুর রিপোর্ট তুলা ফুরিব তুলিব দি বাম্মাজে দেখি বর্মার ইয়ে কি তুলিন তুলে আরা নজানি মন্ত্রণা আরা রোহিঙ্গা হিসাবে আরা রাজ্য বামিস রোহিঙ্গা অর্গানাইজেশন ইউকে তো আরা হালত হন্দিল্লা আরা মাবুইনা কলর জুলুম গরে দে আজ পর্যন্ত দেশ সমাজি আর দেখি অহন পর্যন্ত কি চলে দে হদুন মানুষরে মিলিটারি অকলে মারি ফেলাই হদুন দেখি আর বাইন বইনান অকলর রাজ্য পর্যন্ত আইতো যাইতো নদের দেশের ভিতরে ইলেকশন অতি আইতো নদে ইলেকশন অফ দি বুদ্ধিত নদে তো ইন বেগুলুন দেখি জেনোসাইড হদে ইয়ান আর রিপোর্টের মাঝে বেগুলো হাইলাইট করছি এরে আজ তিন্ন মেহমান সাইরগা মেহমান আসে উগো ইয়েদে আকিলা ইবো ইয়েদে মডারেট করছে ইবো ইয়েদে বেগুনরে দেখি মিটিংর উগুয়া সর্দার হিসাবে মানে স্পেশালি বেগুনরে কন্ট্রোল করি কোয়েশ্চেন এন্ড আনসার অকল গুজে ইবো ইদে গ্লোবাল জাস্টিস সেন্টার দুনিয়া আগাগুরার জাস্টিস সেন্টার হইয়ারে আপনি পিসাইয়া টাইয়ামিয়া টামু সেন্টার বো তো আর উগুইদে আর এরেন হইয়ারে ইবো ইদে আইসিসি কেইসর বাবতে বেশা বেশি জানে আইসিসি মাঝে হামগুজিল ইনভেস্টিগেশন টিমের মাঝে অহন দেখি আমেরিকার হলোকস্ট মিউজিয়াম আইসিজি হলোকস্ট মিউজিয়ামের মাঝে সাইমন যে সেন্টার হদি আনম মাঝে গিয়া হামগরে অহনের কেতু তারা রিপোর্ট গো নিয়ালাই আর গই না আর বাই আরসালান সুলাইমান ইবইদে আইসিজির কোর্টের মাঝে অনরা দেখিবা ইবা দেখি আর ওয়াইঙ্গার কেস বানাই দিয়ান গো মেইন আর গইদে থমাস ক্যান্টানা অনরা আর কানম মাঝে সাইড মাপতা গিলতে সবসর বর্মা মাঝে হামগুজিল তো ইবা আরা বেগুলুম বইয়ার আকান দেখি আরা রিপোর্ট ইয়ানো লঞ্চ করছি তিননান কেস আকান আর্জেন্টিনা আরকান আইসিজি কেস আরকান আইসিসি কেস তিন্ন মাইছে তারা তিন জানার হতা হয়ে তো এরা আইসিসি কেসের বাবদ হয়ে দিয়ে কি বলি হলে আইসিসি কেস আর মুমিকা যার আল্লাহ দিলে অহন ইনভেস্টিগেশন অকল ধর্মর ঘরের বাংলাদেশের মাঝে মানুষ যায় ইনভেস্টিগেশন করছে তো ইয়ান মুমিকা আল্লাহ দিলে বেশি সুন্দর যার আর দিকে আইসিজে মাঝে অহন বর্মাই নমানের প্রভিশনাল মেসাজ ইনল্লাহ হামাকা কান রিয়াকশন আইব আসলানো হয়ে আর দেখি প্রভিশনাল মেসাজ ইনদিকি বাইন্ডিং ইনদিকি বাইন্ডিয়া ইনদিকি জ্যাম মনোহেন গড়ি নহারে ইনরে মানা ফরি তো অহন নমানিলেও আর কেস আইসিজে কেস ইয়ানোর মাঝে কান বেশি ইম্পর্টেন্ট জিনিস অহন ইবাই হই গই দেখি বলে হইলে ইয়ানোর যেতে একখান ফাইসালা হইয়াইবু আল্লাহর হুকুম হইলি এত মাঝে বর্মা দেশের উড়ি দুনিয়া আগাগুড়া তু যে একটা নাফরত আইত পারে ইকোনমিক স্যাংশন অকল ধর্মর হইয়াইব আর জেনোসাইড এন্দিল্লা দেখি কোমুগুয়ারে ফুরাই ফালাই দিয়ে দেশ একলে হনদিন তারা ডিল নগরিব ধর্মর বর্মার ওর একখান দাব্বা হইয়াইব ইয়ান বর্মাইও জানে আই দেখি হামাকা সেই সিয়ানত তু একখান সুন্দর ফাইসালা হইব বলে বুঝের ইয়ানোর হই গিয়ে তো আর তোমাস ক্যান্টানা যার নাকি বর্মা তাইছিল সাইমাত্তা সমাত্তা সবছর আর খানো সাইমাত্তা আসছিল ইবাই হদ দেখি বলি হইলে ইবা আর যে একখান আর ফাইল কেস গুজি আর্জেন্টিনার মাঝে আর বার্মিজ রোহিঙ্গা অর্গানাইজেশন ইউকে তু ইবার লয়ারও তো বেশা বেশি আর কোমর হালত জানে দেই বুতরি বেশি কোমল্লা বালা নিয়তে বাফে আর কোমর হালত গান খেঙ্গুরি বুদুলি বুদি আর সলিডারিটি দিয়া কেল্লা উগ্র কোমর বড় খন্দিলা জুলুমত দিন দেখি ক্যান্টানাই দিকি আর কানগিল মন্ডু বুসিদং আইকাফ বহুত মাত্রা গিয়ে অহনিন হই গিয়ে তো আর কেসিয়ান দেখি আইসিসি টু অহন করিয়ে দেখে বিয়ানি বেশি ইম্পর্টেন্ট কেসিয়ান দেখি মুমিকা যাই ফারিব আল্লাহর হুকুম হইলে আর আর্জেন্টিনার কেসিয়ান যদি ইনভেস্টিগেশন খুলি ফাইলে মতন আর বহুত কিছু আর যে জুলুম গজ্জি আর মা বই নাইন বাই আইন কলরে হামাকা তারা কান সাজা তারা ফাইবাল্লা ইয়ান হামাকা আর মুমিকা যাই ফাই জুমদা আশা করি তো অবয়ান বই নাইন কল অনরা খেম মাদে আমি বহুত মাত্রা ছিলাম যেতে নাকি অনরা দেশ ফারাই এসো অনরার বেশা বেশি জুলুম গজ্জি বেশি জুলুম অকল গজ্জি আই নিজেও দেখি আর বাই আইন বই নাই জান তারা আর কানম মাঝে আর কানম মাঝে আসছিল অনরা বেগুনো হই পারো আর দেন তারা দেশ বিদেশ তো গিয়ে ইন্টারন্যাশনাল গ্রুপ অকল গিয়ে যে জুলুম গজ্জি নারা জিন্দিগি থরাই না ফাইজুম আর ইনসাফ অনরা যে হইও আর যে জুলুম করছে স্পেশালি আর বই নাই আর মা কলরে বেশা বেশি জুলুম অকল করছে হা মাকা আর ইয়ান দেখি ইনসাফ কর দেয়ান আর ফাইবাল্লা খুশি করি যাইম অনরার ফাঁতে আর আসি আর যে জুলুম করছে আর জিন্দিগি নফরাইম আর বাই বই নাই আর ইনশাআল্লাহ তাকিদ দি টাইম আর বাংলাদেশের রুল এন্ড রেগুলেশন ল এন্ড অর্ডারের ফুনি আর থাইকুম সুন্দর করি আর হনো মুটে ইয়ান আকান ইন যে জুলুম গজ্জে সাজাইন ফা গুরুবু ইয়ান আকান আখতা আর আকান হতো ইয়ে আর তু একু টাইম মাঝে আর দেশত আর ওতনত আর জায়গা আর তু যাই ফারা ফুরুবো যাইবাল্লা যে লাইনে হামকল গড়া ফরে ইন আর অ্যাডভোকেসি ইন্টারন্যাশনাল লেভেল তো ওদের কোশিশ গড়া ফুরুবো কোশিশ গড়িও যাইম মন্তর কেস ইন দেরি যাইলিও হদুল হার আবৈব দিয়ে আছে মন্তর কেস ইনত দরিয়া বহুত কিছু বর্মার গভর্নমেন্ট তু মিলিটারি তু বহুত কিছু তারা তু বদলে আফুরবদ আছে কেস ইনো প্রেশার লই আর হক ফাইম দে শাসো বেশা বেশি আছে মন্তর ইয়ানাক কানে দে এক জাস্টিস এন্ড অ্যাকাউন্টেবিলিটি হতে ইনসাফর হতা ইনসাফ ফাইবার হতে আর হক ফাইব দে আর আল্লাহ কান শাস আছে আর ইয়া কোশিশ করি ইনশাআল্লাহ আর ব্রক বলি ন দুনিয়ার মাঝে আরো রোহিঙ্গা অর্গানাইজেশন অকল আছে বেগুনে কোশিশ করে আর হক সই গান লই আর যাই ফারিবল্লা কোশিশ করি যাইম ইনশাআল্লাহ আর স্পেশালি কেমত আছে দে ইয়ং জেনারেশন অকলরে এম্পাওয়ার করিবাল্লা তা কথা নিবাল্লা তারারে ফন্না ফরাই ফারিবাল্লা তারার দিকি অহন গুড়া গুড়া ভাই আইনকল আছে তারারে মানুষ বানাইবাল্লা আর তু কোশিশ করা করবো ইয়ানোর বাবতী আর এর হতা হই তো আতাল্লা বলি আর বেগুনে এসল্লুকর সাথে বেগুনে কোশিশ করি যাই আর হক খোঁজে আনম মাঝে আর ফুল সিটিজেনশিপ আর রোহিঙ্গা এথনিক আইডেন্টিটি লই আর ইয়ান লইব মুমিকা যাইম দি আর বর্মার আর খানর আর ওতন ইয়ান আর মেডি আর হক আর তুফা হইব এর আর হন হোয়াইট কার্ড হন এনআরসি কার্ড দেই ন বর্মার মাঝে কম বেগুনে জেন্দিলা ফাই এন্দিলা হক আর তু ফা ফুরুবু টাইনিনতা হিসাবে নাইঙ্গান্তা আপিয়েওয়া হিসাবে হামাকা আর fahurubo faibalai kushi gujum ar yano mazi hono akan compromise nai arar komar hok hoje yanot hono white card NRC card or hota in nai arar hok hoye the full citizenship Rohingya with ethnic identity toi hamaka nainganta akhoi muya ba nainganta akhoi apie wara tu fahurubo Rohingya time da hodde yano arar hok fahurubo yano ron ara gori jayum inshallah honorable gune dua gojo jantara bare arar friend okol ajjaire Akila Erin Arsalan Suleman toi ba the Thomas Cantana jantara aro oina lawyer kolo asi toi taralla jantara kushi gor tarare honorable gune bala nozore saiba taralla dua goriba arar fuati arar ko je zulum fayi yanor fuati dunia asi dunia bala bala lawyer kol arar fuati saati ase inshallah I buzidde arar komor akan halot indilla hono notaibu taimor ur akan boduli aibo toy arar arayu kushish gori boduli aiballa arar hok faiballa arayu kushish gori dunia ya aralla kushish gorer begune ara ezone adar muhabbator sate esolukor sate momika gori jai inshallah arar Allah kamyab gori begunore assalamu alaikum wa rahmatullahi wa barakatuh. Thank you so much, Akila, for your wonderful moderation, and thank you, Erin, for your wonderful explanation for ICC case and for the report, and thank you, Arsalan, brother. You are an architect of this Gambia case, and so I hope you will move forward, show solidarity for the justice of the Rohingya. And my brother Thomas, we've been long time working on for the rights of for the human rights and democracy for Burma, visited many times to Argentinian state. Of course, you know what the situation we are facing, you have witnessed. So I believe that we can move forward from this panel to hopefully after 1 year, we can see after a few months, maybe we will see much developments and we can have another event maybe which will be in person or much more with good news. Thank you so much joining with Burmese Rohingya Organization UK event today. I really wish all of you all the best for all your work you're doing. Thank you again.
Thank you, Tunkin.
Thank you, Tin Can. Thanks for having us. Bye.
Thank you, Kin.